This week, I received a letter from Turning Point titled Demand to Cease and Desist Defamatory Comments. This is the first step when someone sues you for defamation. I know there are a lot of people out there making videos about Turning Point, so you should pay attention to this. They have started sending out cease and desist letters, and for some reason, they've decided to start with me. This letter is showing the world the type of organization Turning Point has become under Erica Kirk. They want to send legal letters to small YouTube creators.
Hello and welcome back to TriggerSmart. I would guess by now, especially based on yesterday's live streams, that you have seen the video by Wilson Finance. And Zach shares that TPUSA, at least a lawyer, has reached out to him and sent him a cease and desist letter. And he went over some of the details. He had not released the official letter yesterday. As of midnight, he did. So I'm going to cover that today and going to go deeper into the legal side of things and what it actually means. Like, does this mean that he's officially being sued? Does it mean they can sue him? And what kind of things that you say or show can actually lead to an official lawsuit? Let's get into it. And just really quick, one thing I do want to share is this is not the first time that TPUSA has sent out cease and desist letters or tried to sue someone, even before Erica Kirk. So check this out. This was The View, and I believe it was Whoopi Goldberg. And the girls had to come out and do an apology and fix what they said due to a cease and desist.
Now we begin with a shocking apology just a short time ago from the ladies of The View to Turning Point USA. A war of words broke out after the conservative group was rallying the next generation of voters at its youth summit in Tampa, Florida this weekend. And the liberal panel just couldn't help themselves. The group sent a scathing cease and desist letter after hosts on The View suggested that Turning Point had embraced neo-Nazis who showed up outside the event. Watch.
This Turning Point conference, neo-Nazis were in the front of out there in front of the conference with anti-Semitic slurs and, the Nazi swastika.
I think it's important that every single person that attended that Turning Point, every Republican speak up against the swastikas, against the Nazi flags that were waved.
You let them in.
President, open your
You let them in and you knew what they were.
Right.
Just to be clear here, there were supposedly these Nazis or neo-Nazis out in front of some kind of demonstration or event for TPUSA. And these ladies are factually stating that TPUSA was endorsing them somehow because they were there.
So you are complicit. I want to make a quick clarification about the neo-Nazis at the Turning Point event. They were outside protesters. My point was more metaphorical, that you embraced them at your thing, I felt.
Well, fast forward to this morning. The hosts apologized before quickly cutting to commercial. Watch.
On Monday, we talked about the fact that there were openly neo-Nazi demonstrators outside the Florida Student Action Summit of the Turning Point USA group. We want to make clear that these demonstrators were gathered outside the event and that they were not invited or endorsed by Turning Point USA. A Turning Point USA spokesman said the group, quote, 100% condemns those ideologies, and said Turning Point USA security tried to remove the neo-Nazis from the area but could not because they were on public property. Also, Turning Point USA wanted us to clarify that this was a Turning Point USA summit and not a Republican Party event.
Typically, when someone receives a cease and desist or some other type of lawsuit based on something they've said or shown, this is what you'll see. You'll see a scripted apology or something similar, right? And in this case, they were saying that the neo-Nazis were at a TPUSA event. TPUSA embraced them, right? They said all this stuff as factual information on their show. And then now they're in a later show, they're apologizing. And they're basically saying, well, we were incorrect. And when they keep saying that a spokesperson said, then that very likely that's a letter similar to what Wilson Finance received, where a lawyer is sending him things like talking points, like you need to correct this to this, and you need to say this instead of that.
Sean, something that struck me in the cease and desist letter was the sentence that specifically The View hosts insidiously and cavalierly stated that TPUSA let the neo-Nazis into its event, metaphorically embraced them, and it went on. Insidiously and cavalierly. And I felt that perfectly summed up exactly what those women were saying, which is something so deeply toxic and also so lightly thrown out there.
And that's where a lot of people get into trouble is if you're sharing something that seems as though it's a fact. For example, some channels and some people on X and things like that will say, factually, this is what happened 100%. Someone challenge me. Unless you have facts and evidence that would back that up in court, then it's just your opinion, but you're not sharing it as your opinion. You're sharing it as it's a fact, okay? And that can lead to these legal issues, especially cease and desist is kind of the first level, right? They'll try and get you to shut up or be quiet or say things differently, but eventually it can get to an actual lawsuit, right? And these are very large, powerful companies.
Or maybe there is, because when people like Nick Sandmann and Kyle Rittenhouse start suing, these major news organizations for destroying their reputations, maybe some of the people who put forth these narratives will think about it before it escapes their mouths. And, it's like, we all know that. We all know there are lines that you can't cross when you are talking about a story, when you're analyzing a story, when you're angry about something. You still have to stay within the bounds of what happened factually. And I think what happened there was they didn't watch the tape. They didn't even do any investigation. They were just blathering about what happened. And I don't think, if this did go to trial, saying to a judge, well, it was more of a metaphorical.
So there you go. That is a case from TPUSA sending a cease and desist to the ladies of The View and them correcting what they said, because what they said as a fact on their show was not, in fact, true. So now that I've set the precedence that this is not a new thing, because a lot of people are saying that, hey, under Erica Kirk's TPUSA, now they're suing people. That's not true, okay? And actually, it's not even a lawsuit officially yet. It's just a cease and desist. Now, Wolves in Finance had said that, this was a first line to a legal issue. It could be, but a lot of people are saying that Turning Point is only doing this because of Erica Kirk's leadership, and this is who they've become, right? They're trying to imply that she has something to do with it. Based on what I've shown so far, it's pretty clear that this is not a Erica Kirk TPUSA thing. This is a large company TPUSA thing that has happened in the past before she even became CEO. So now let's get into the letter. This letter is directly on Wolves in Finance on X, which I believe is called Finance Wolves. But this is to Zach De Gregorio from Wolves in Finance. This is from South Bank Legal. Okay. So this is theoretically from a legal entity. Now, you don't, like Barron was saying last night, you don't have to be a lawyer to request or send a cease and desist. But if you're not a lawyer, you cannot have legal speak or legal threats or anything like that in the letter. Okay. This is the official letter, and this is on the Wolves Finance page on X. This is sent to Zach of Wolves in Finance, demand to cease and desist defamatory comments. So that implies defamation of character or defamation of the company, right? Which is why he probably thinks it's opening up for legal issues. We represent Turning Point USA and all the subsidiaries here. If you are represented by an attorney, please provide this to your attorney. Since Charlie Kirk's assassination, you have used Wolves in Finance website and podcast to make numerous defamatory statements about the TP entities and their staff, board, and contractors. We are writing to demand you cease and desist making these false and damaging statements immediately. While the TP entities welcome vigorous debate and honest questioning, just like Charlie did, there's no room for publicly repeating patently false statements that injure another person's reputation. Such statements are what the law categorizes as defamation. Now, again, defamation is the lawsuit. Cease and desist is the warning, okay? Under the law, defamation is published as a false statement that impeaches a person's honesty, integrity, virtue, or reputation. And then they provide some cases. In certain cases, a party who has been defamed may recover substantial damages, even without proof of special damages. Then another case, and even where a party must prove special damages, these can be significant. Many statements you have made publicly in your YouTube podcast about the TP entities qualify as defamation. So they are saying there is defamation to them. They are demonstrably false and were made to impeach the TP entities' reputation. And they have caused tremendous damage to the TP entities, including leading to threats of violence being directed towards certain individuals at the TP entities. I address some of the most egregious defamatory statements that you have made below. Second page. There's 4 pages. Response to specific false statements. November 16th episode. In your November 16th YouTube podcast bombshell, The Turning Point USA Commit Fraud, you made numerous false claims, including Charlie Kirk ordered a Doge-style audit that was never conducted. Someone at Turning Point decided not to file 990s. In 2023, $650,000 may have been funneled from TPUSA through TPUSA Action to TPUSA PAC to evade campaign finance restrictions. They say, with respect to the audit statement, your video represents the basic content of Mr. Kirk's memo. TPUSA never planned a Doge-style audit. Indeed, TPUSA's COO announcement concerning the Doge effort never used the word audit. Rather, the announcement makes clear that TPUSA was doing what it has always pledged to donors, ensuring it was being most efficient with its funds and time and making changes to foster greater efficiencies. Moreover, TPUSA hires a third-party audit firm to conduct an audit every year. And I believe that's been discussed in depth too in other videos and other channels about this third-party firm. So it's interesting that they say Doge-style audit was ordered, but it should be Doge-style effort. I believe that's what they said officially. And then he's saying that they hire a third party to do the official audits. Now, Doge by default is implied as an audit, right? That's typically how it's always been used, but they want to change the verbiage here. Your comment about the 990s is also patently false. The TP entities timely filed their 990s for FY24, and I believe he did correct that, right? He mentioned that they hadn't been filed, and then later he showed that they finally showed up and had been filed, I believe, in May. Finally, contrary to your claims regarding the $650,000, that money actually went from TPUSA Action to TPUSA as a reimbursement for an event expense. There was nothing nefarious about that transfer. November 30th, 2025 episode. In your episode, Explosive, More Fraud at Turning Point USA, you made several false statements, including there was more fraud at TPUSA, which implies that there was fraud in the first place, right? So in that case, that goes back to kind of the defamation and the cease and desist. If you're saying there's more fraud, that means you have proof, 100% proof of fraud in the first place. ATP had ghost employees because FY23 reported $3.7 million in salaries, and FY24 reported $4.5 million in salaries, but ATP had between 0 and 24 employees during this time. And you mentioned that donations to TPUSA Action increased from $10.7 million in 23 to $27.2 million in 24, and suggested that Tyler Boyer may have been recruiting these donors away from TPUSA to undermine MAGA and benefit himself. Page 304. First, there was no fraud at Turning Point USA, much less more fraud. Your assertion otherwise is baseless and false. So here, they're saying that the more fraud implication means that he has proof of fraud in the first place. Second, ATP did not and does not have ghost employees. Rather, ATP had 80 employees in 23 and 108 in 24. There was, however, an inadvertent error in ATP's filing which failed to note these employees. And ATP is in the process of rectifying that inadvertent error, but it is false to assert, as you have done on your YouTube show, that ATP has ghost employees. So he did find an error. He was correct that they didn't list employees, and they're saying that they are fixing that. Third, contrary to your statement on your YouTube show, there's nothing nefarious in TPA's increased donations during an election year. Donors naturally direct more money towards election activities in election years, especially to organizations like TPUSA Action, and that can engage in lobbying and political activity during election years. Accordingly, you were wrong to assert that the increased donations to TPUSA Action evinced any sort of wrongdoing on Mr. Boyer's part. And really quick, I just want to point out that there have supposedly been other people that have received similar types of letters, cease and desist. On X, there are claims that they received this stuff, months ago. So Wilson Finance, though he's saying he's the first one to be attacked by them, it doesn't seem that that's the case, but this might be one of the bigger ones, right? But people in the past said that they had false statements and some other things that TPUSA or a lawyer, someone reached out to them and supposedly, allegedly said that they were to cease and desist. Then it says December 7th, 2025 episode. Then it says in your December 9th, 2025 episode. So those don't match. I don't know if he noted that before, but December 7th and December 9th clearly are not the exact same video. But they name it Top 10 Clowns of the Year. You made statements that supposed discrepancies concerning the use of drones at Utah Valley University on September 10th, 2025, but there was no discrepancy. UVU prohibited TPUSA from flying drones for security purposes during the event, but did allow a TPUSA media production drone to briefly fly over the location before the event to collect limited B-roll footage. Now, I would say that security of Charlie Kirk is significantly more important than getting some B-roll for media. If they allow the media drone, why would they not allow security drones? And most likely, they're probably similar in size, right? The security drones aren't necessarily some big, crazy thing. It can just be a typical like DJI 3 Air or something similar. And it's very strange to me that they would allow the media, but not the security. And when I looked into this before, it seems as though the university has a form that you can fill out and you can request to get permission to fly drones. So I'm not sure if the security just didn't do that or didn't know about it, but saying that they were there, on the 24th, which is like 2 weeks before the event, means they had plenty of time to talk about that stuff, ask those questions, and get the forms and things filed to get permission. So that's all still very strange to me. December 14th, in your December 14th YouTube video, Tim Pool rants about Turning Point. You made several defamatory statements, including asking whether the money sent to 110 LLC was a bribe to Jake Hoffman, and asking why ATP lists its COO Tyler Boyer as an independent contractor. First, TPUSA contracts with 110 LLC for legitimate services. The money you ask about is spent on marketing and advertising services. Any claim that it is a bribe is false. Now, this could be true. Marketing is typically a large budget for large companies, in addition to their technology budget, which is typically 70% sometimes of their budget. Second, ATP lists its COO as an independent contractor because his substantive role for ATP is more in line with the contractor classification. This one I'm not sure about because I think that he's been listed as a contractor for a very long time, like multiple years. And I would have to double check on that. I don't know if that's factual or not, but that's what I've been hearing and seeing in other videos. They're saying that Tyler Boyer has been listed as a contractor for multiple years. More generally, you have accused the TP entities of being shell companies. This too is false. The substantive description and roles of each of the TP entities can easily be seen by reviewing each organization's 990. Claims that any of the TP entities is a shell company is patently false. And then this is our last page. In your December 28th, shocking Turning Point fraud gets worse. You recklessly repeat many of the previously described falsehoods, and again directed viewers to the home address of Mr. Boyer, Tyler Boyer, which has resulted in threats to Mr. Boyer's safety. You also falsely suggested Turning Point PAC sent bribes to 110 LLC when the payments were made for legitimate services. The fact that Zach put this document up, again, blacked out address, means that he was not doxing Tyler Boyer. If people went and looked at this document themselves, which is publicly available, that Tyler publicly put his address on, that is not Zach's responsibility, okay? I'm happy to provide you with further information confirming what I have set forth above. While the TP entities have actionable and meritorious defamation claims against you, the TP entities are not looking for litigation. Rather, their interest is in the truth and making sure the public record is accurate. Please confirm that you will publicly correct your false statements immediately. They didn't say specifically what they're going to threaten him with. Clearly, it looks like it would be defamation. And if that's the case, based on how you word things, this could open up all creators, all people on X, all investigators, all news stations. Everyone could all be opened up to this type of thing. Additionally, please contact me before you publish anything more about any of the TP entities or their finances, as I can provide you with accurate information to answer any legitimate questions you may have. Otherwise, you will be acting recklessly and maliciously if you go ahead and publish further unsupported assertions about the TP entities without giving me the opportunity to provide you with the truth in advance. Now, you could look at this one of two ways. It looks like as though they're being fair, saying that feel free to report on this stuff, but at least come to the source and let us give you the information, maybe the numbers, where things were filed and that kind of stuff, to give that factual information from them before he shares it out publicly. Even if he disagrees with it or, whatever else, at least he would have their numbers. Another way of looking at this, and some people have already mentioned, is maybe this is them trying to control the narrative, right? And for any company in any situation, especially with things like this, ongoing investigations, the Charlie Kirk assassination and all that, you want to control the narrative as much as possible to prevent damage control and other things. Now, I'm not saying that they're implied in anything. I'm just saying that it's not uncommon to want to control the narrative, right? The TP entities expressly reserve all rights. In addition, please preserve all evidence potentially relevant to your false statements and take affirmative steps to ensure that no potential relevant documents, data, communications, or evidence, whether physical or electronic, are deleted, lost, or destroyed. This preservation obligation extends to data on personal cell phones and tablets and encompasses paper documents, presentations, spreadsheets, emails from all email accounts, both personal and business, calendar and contact information, electronic chat messages, text messages, WhatsApp, Signal, Telegram, etc., any other form of digital communications, and documents in the shared drive. Sincerely, Paul Edgar Harold. So basically what that's saying is anything he's using to support his false statements that they're claiming, he has to hold on to all of that, they're saying, and make sure that he's taking steps to ensure that none of it's destroyed or lost or hacked or taken, right? Those type of things. That is the Wilson Finance cease and desist letter in its entirety. Now let's look at who Paul Edgar Harold is. So this is according to Grok, and obviously you can get details incorrect, but this is the version that came out. Paul Edgar Harold is a experienced litigator based in South Bend, Indiana, specializing in complex commercial disputes, white-collar defense, and appellate matters. He's a partner at South Bank Legal, which is what we saw on the letter to Wilson Finance, where he represents sophisticated clients in high-stake litigation, including Fortune 500 companies. He earned his JD Magna Cum Laude from Notre Dame Law School in 2005, where he serves as article editor for the Notre Dame Law Review. He received a BA Summa Cum Laude from Franciscan University of Steubenville. He was admitted to the Indiana Bar in 2005 and remains active and in good standing. He was admitted to practice before several federal courts, including Appeals 7th Circuit, U.S. District Court for Northern District of Illinois, U.S. District Court for the Northern District of Indiana, and U.S. District Court for the Southern District of Indiana. So according to all of this, it appears as though his primary practice is in Indiana, and I believe Wilson Finance is in New Mexico, and then obviously TPUSA is in multiple places, but primarily it sounds like they're in Arizona. After law school, Harold clerked for 4 years at the federal trial and appellate levels, gaining hands-on experience in judicial processes. He joined South Bank Legal, where he built a practice focused on business litigation, employment and labor law, lawsuits and disputes, and general commercial matters. He has taught commercial law as an adjunct professor at Notre Dame Law over a decade, contributing to legal education. He's co-authored scholarly work, and he's recognized in the Chambers USA Guide for his litigation expertise, with clients praising his ability to handle complex disputes effectively. Harold's practice emphasizes strategic problem solving in areas like commercial litigation and white-collar cases, drawing on his federal clerkship experience and academic background. He is affiliated with professional groups such as the Indiana State Bar Association's sections on appellate practice, business law, and litigation. Now, Baron Coleman went over this and covered it in a live stream, and he mentioned two things. He said first, he would file a bar complaint about the lawyer practicing in the wrong state. So this lawyer is in Indiana, and he seems as though he's practicing in Arizona. So that's one thing that Barron had mentioned. He also said he would file a bar complaint in the lawyer's home state in Indiana for the same reason. I'm not sure. I have no legal experience in this area, but those are things that Barron said would be the first things he would do. And really quick, I want to go over the history. So Turning Point USA has a history of issuing cease and desist letters and pursuing or threatening defamation-related legal actions in response to what it perceives as false or harmful statements. Below is the summary. 2021, threat of defamation against Arizona Commissioner. TPUSA threatened legal action for defamation against Arizona Corporation Commissioner Sandra Kennedy, Democrat, after she requested a federal investigation into the organization's alleged role in the January 6, 2021 Capitol riot. TPUSA denied involvement in the riot itself, though it acknowledged organizing transportation for students to attend the preceding protest rally. No lawsuit appears to have been filed, but the threat was publicized. So this first one in 2021, they threatened defamation lawsuit against Arizona Commissioner, and to date, there was no lawsuit that's appeared, but the threat was publicized, okay? 2022, cease and desist to ABC News The View. We showed the video of this before. In 2022, TPUSA sent a cease and desist letter to ABC News demanding retraction of defamatory statements made on the talk show The View. The letter, drafted by TPUSA's in-house counsel, gave ABC until July 27th, 2022, to retract and apologize or face litigation for reputational and financial harm. The View issued an on-air clarification and apology shortly after, stating the neo-Nazis were outside and the event was not endorsed by TPUSA. No full lawsuit followed. 2023 to 2024, miscellaneous reports of cease and desist letters. In late 2023, an individual posted on Reddit claiming to have received a cease and desist from TPUSA as a precursor to potential defamation lawsuit, though details were limited to a general legal threat. Broader reports from this period reference TPUSA's use of legal threats against critics, but specific cases are sparse in public record. 2025 to 2026, recent cease and desist and defamation threats. Following the September 2025 assassination of TPUSA founder Charlie Kirk, the organization and the Kirk family announced preparations for defamation lawsuits against media outlets, influencers, and figures accused of smearing Kirk's reputation post-mortem. TPUSA spokesman stated they were logging it all and had good lawyers to pursue claims. Specific actions: sending cease and desist letters to small YouTube creators and influencers, such as Finance Wolves, for videos alleging TPUSA's financial fraud. The letters demanded public corrections or threatened lawsuits. Targeting supporters of Candace Owens, a former TPUSA affiliate who allegedly spread lies about the organization, prompting recipients to delete posts and scramble to retract statements. Owens herself was referenced in discussions of potential lawsuits, with one post suggesting a cease and desist to her was a terrible idea, but confirming it occurred. So it's interesting that they're targeting these smaller channels and supporters of Candace, but not Candace directly, at least not yet. These recent efforts appear focused on online and social media defamation, with TPUSA emphasizing documentation for broader legal action. As of January 2026, many of these are in the early stages, and outcomes like filed lawsuits are not yet fully reported. TPUSA's approach often starts with cease and desist demands before escalating to lawsuits, citing harm to reputation, donors, and partnerships. Note that while TPUSA has received cease and desist letters from Young Americans for Liberty in 2019 over membership solicitation, the query focuses on those it has sent. Now, I know there's a lot of reading here, and obviously you can just put this on your headphones and just continue what you're doing and listen, but I think it's really important to go over the definition of defamation in the law. According to Grok and other sources, I did multiple different searches and kind of came up with this final version. Defamation is generally defined as a false statement that harms or injures a third party's reputation. It is a civil tort, a wrongful act that can lead to a lawsuit, governed primarily by state laws in the United States, though it is also shaped by federal constitutional protections under the First Amendment. This includes both libel, which refers to written or published statements, such as in articles, social media posts, or books, and slander, which involves spoken statements like verbal comments or broadcasts. The key distinction between libel and slander is the medium. Libel is typically considered more permanent and thus potentially more damaging, while slander is transient. In some states, certain types of statements are considered defamation per se, meaning they are inherently harmful. For example, false accusations of a crime, immorality, or professional incompetence, and harm is presumed without needing to prove specific damages. Now, this is similar to what Wilson Finance had in his letter. Defamation law aims to balance protecting individuals' reputations against freedom of speech and expression, legal requirements to sue for defamation. To successfully sue for defamation, the plaintiff must typically prove the following four elements in court. These requirements are based on common law principles and may have slight variations depending on the jurisdiction. A false statement of fact. The statement must be demonstrably false and presented as a fact, not an opinion. Peer opinions are generally protected under the First Amendment and not actionable. However, if an opinion implies undisclosed false facts, it could still qualify as defamatory. Publication or communication to a third party. The false statement must be published or shared with at least one other person than the plaintiff. This could be through writing, speech, or even gestures in some cases. Fault on the part of the defendant. The plaintiff must show that the defendant or the person making the statement acted with a certain level of fault. Okay. For private individuals, this is usually negligence. For public figures or officials, a higher standard of actual malice implies, meaning the defendant knew the statement was false or acted with reckless disregard for the truth. And then, of course, you have to prove damages or harm. The plaintiff must demonstrate that the statement caused harm, such as reputational damage, emotional distress, or financial loss. In cases of defamation per se, damages may be presumed, but in others, actual harm must be proven. Some states limit damages to actual losses, while others allow for punitive damages if malice is shown. Key defenses and considerations. Defendants in defamation lawsuits have several potential defenses. Truth. If the statement is proven true, it's an absolute defense. Okay? And this is where discovery can come in. Privilege. Absolute privilege protects statements in certain contexts, court testimony, and legislative debates. Fair comment or opinion. Protected if it's clearly an opinion on matters of public interest. consent or retraction. In some cases, if the plaintiff consented or the defendant retracts a statement, it may mitigate damages, like we saw with The View. Broader developments. Supporters are rallying, sharing the video, and predicting backlash against TPUSA for targeting tiny channels. Separate from these letters, there's talk of a class action lawsuit against TPUSA for donor fraud, with a notice to preserve documents sent by Real George Webb. No resolutions yet. Discussions emphasize potential for court-mandated transparency if suits proceed. Now, this is also important. There are cases where companies sent cease and desist letters and lost the lawsuit. It says, yes, there are several documented cases where companies issued cease and desist letters, often as a precursor to litigation, to threaten people, to put them into fear so they stop saying or doing what they're doing, and ultimately lost in court. These losses frequently stem from frivolous claims, lack of evidence, or misuse of legal threats to silence competition or criticism. Such cases can result in sender paying the recipient legal fees, facing public backlash, or having their claims dismissed. It goes on to talk about some historical cases. And also, there have been cases where the allegations prompting the cease and desist were later proven true. There were instances where companies sent cease and desists to critics or whistleblowers alleging corporate wrongdoing, only for those allegations to be validated later through investigations, indictments, or admissions. This can occur in whistleblower scenarios where the C&D is used to intimidate, but external probes confirm the claims. Such outcomes often lead to the company facing penalties while the critic is vindicated. And then it shows some examples. These scenarios often invoke the Streisand effect, where attempts to suppress information amplify it, leading to greater scrutiny. In whistleblower cases, laws like the Defend Trade Secrets Act provide immunity if disclosures are made to authorities, but companies sometimes misuse C&Ds anyway. If allegations are proven true, the sender may face additional claims for malicious prosecution or abuse of process. So I think in light of all this, the key takeaways are, if you are going to talk about a topic, a company, a subject, that you're giving your opinion, unless you have proof, 100% proof, that you only share things as allegations or your interpretations of situations and not as fact. And then, of course, make sure if you receive one of these letters that you take it seriously and make sure you get a lawyer and get set up. But in light of this case with Wilson Finance, it would seem that in theory, based on their letter, if they're being honest, that they want him to change how he's saying certain things, correct some mistakes that they say he's made, and then they also want to basically have him consult them with any future videos or information that he puts out to make sure he gets the information directly from them first. I'm very interested to hear your thoughts. I know this was a longer one and a lot of like legalese and more information, but I think it's important. And in the comments, I'd like to hear, do you think that TPUSA, or in this case, technically the lawyer that's speaking for them, do you think they have a true case of defamation from Wilson Finance based on the videos he's done? And as always, don't forget to like, subscribe, and share this around. And if you want to support the channel, I have links down in the description. See you in the next one.